Hello there, and welcome to the International Jurisdiction Academy channel. I am Carlos Campos, and I'm here to talk about the AL-ADSANI case against the United Kingdom, decided on October 10, 2001, by the European Court of Human Rights, sitting as a Grand Chamber. This judgment originated from an application lodged by a dual British Kuwaiti national, Mr. Suleiman Al-ADSANI, on April 3, 1997. Mr. Al-ADSANI alleged that the English courts, by granting immunity from suit to the state of Kuwait, failed to secure enjoyment of his right not to be tortured and denied him access to a court, contrary to Article 3, Article 6, Section 1, and Article 13 of the European Convention on Human Rights. Mr. Al-ADSANI was a trained pilot and went to Kuwait in 1991 to assist in its defense against Iraq. During the Gulf War, he served as a member of the Kuwaiti Air Force, and after the Iraqi invasion, he remained behind as a member of the resistance movement. In that period, he came into possession of sex videotapes involving Sheikh Jaber al-Sabah al-Saud al-Sabah, who was related to the Emir of Kuwait and was said to have an influential position in Kuwait. By some means, these tapes entered general circulation, for which the applicant was held responsible by the Sheikh. According to Mr. Al-ADSANI's allegations, the Sheikh and two others took him in a government vehicle to a Kuwaiti prison, where he remained imprisoned for several days, was repeatedly beaten, and forced to sign a false confession. After that, the Sheikh took him to the palace of the brother of the Emir of Kuwait, where he was subjected to other acts of torture, including being dragged into a room that was then set on fire. He then returned to England, where he spent 6 weeks in a hospital being treated for burns covering 25% of his total body surface area. He also was diagnosed as suffering from a severe form of post-traumatic stress disorder, aggravated by the fact that, once in England, he received threats against his life and well-being. In August 1992, Mr. Al-ADSANI initiated civil proceedings in England for compensation against the Sheikh and the state of Kuwait. The proceedings were later reissued to include two other individuals as defendants. In July 1993, the applicant was granted leave to serve the proceedings on the individual defendants, but not on the state of Kuwait. The Court of Appeal examined the case in March 1996 and held that state immunity applied in respect of the alleged events in Kuwait, and that the applicant had not established that the state of Kuwait was responsible for the threats made in the United Kingdom, and therefore rejected the applicant's claim. Mr. Al-ADSANI contended that Article 3 of the European Convention, read in conjunction with Articles 1 and 13, required the United Kingdom to assist one of its citizens in obtaining an effective remedy for torture against another state. The grant of immunity from civil suit to the state of Kuwait had, however, frustrated this purpose. The United Kingdom submitted that the complaint under Article 3 failed on 3 grounds. First, the torture was alleged to have taken place outside the United Kingdom's jurisdiction. Secondly, any positive obligation deriving from the European Convention could extend only to the prevention of torture, not to the provision of compensation. Thirdly, the grant of immunity to Kuwait was not in any way incompatible with the obligations under the European Convention. The applicant also alleged that he was denied access to a court and that this constituted a violation of the Article 6, Section 1 of the European Convention. he mentioned that the House of Lords in Pinochet had accepted that the prohibition of torture had acquired the status of jus cogens norm in international law, and that torture had become an international crime. In these circumstances, there could be no rational basis for allowing sovereign immunity in a civil action when immunity would not be a defense in criminal proceedings arising from the same facts. The United Kingdom submitted that Article 6, Section 1 did not apply to the proceedings on a number of grounds, but that even if it did, any interference with the right of access to a court was compatible with its provisions. Its main point was that Article 6 could not extend to matters outside of the state's jurisdiction, and that, as international law required an immunity in the present case, the facts fell outside the jurisdiction of the national courts and, consequently, Article 6. The court noted that the alleged torture took place outside the jurisdiction of the United Kingdom, and that the United Kingdom authorities didn't have any causal connection with its occurrence. Therefore, it could not be said that the United Kingdom was under a duty to provide a civil remedy to the applicant in respect of torture allegedly carried out by the Kuwaiti authorities. And the court held unanimously that there had been no violation of Article 3 of the European Convention. The court also noted that sovereign immunity pursues the legitimate aim of promoting good relations between states, and stated that measures that reflect generally recognized rules of public international law on state immunity cannot, in principle, be regarded as imposing a disproportionate restriction on the right of access to a court. The court accepted that the ill treatment alleged by the applicant could be categorized as torture within the meaning of Article 3 of the Convention, and also that the prohibition of torture has achieved the status of a peremptory norm in international law, but it observed that the case concerned immunity of a state in a civil suit for damages and not the criminal liability of an individual, as in Pinochet. Therefore, the court found itself unable to discern in the international instruments, judicial authorities, or other materials any firm basis for concluding that a state no longer enjoys immunity from civil suit in the courts of another state where acts of torture are alleged. For these reasons, the court held by 9 votes to 8 that there has been no violation of Article 6, Section 1 of the European Convention. Unlike the majority, Judges Rosakis, Keflesh, Wildeberg, Costa, Cabral Barreto, and Vachich considered that the applicant was unduly deprived of his right of access to English courts. They noted that the English courts, when dealing with the applicant's claim, never resorted to the distinction between criminal and civil proceedings, but simply denied that the prohibition of torture was a jus cogens rule. To them, the main reasoning of the majority that the standards applicable in civil cases differ from those applying in criminal matters regarding a conflict between the prohibition of torture and the rules on state immunity, that this main reasoning is not consonant with the very essence of the operation of the jus cogens rules, and that the acceptance of the jus cogens nature of the prohibition of torture entails that the state allegedly violating it cannot invoke lower rules, in this case those on state immunity. Judge Lucates agreed with this joint dissenting opinion, but preferred to adopt as his main reasoning that any form of blanket immunity applied by a court in order to block completely the judicial determination of a civil right without balancing the competing interests is a disproportionate limitation of Article 6, Section 1 of the European Convention. And finally, Judge Ferrari Bravo, in his dissenting opinion, mourned what he called a golden opportunity to issue a clear and forceful condemnation of all acts of torture and to deliver a courageous judgment. The AL-ADSANI case is one of 3 decisions of the European Court of Human Rights in 2001 that represents a starting point for the discussion on the relationship between immunity from state jurisdiction and the protection of human rights. The others are Fogarty against United Kingdom and McElhenney against Ireland. All 3 cases arose from the rejection of requests for pecuniary reparation for the practice of unlawful acts by foreign states, and in all of them the European Court held that immunity from jurisdiction consists of a reasonable and proportional restriction of the right of access to a court, as it pursues a legitimate goal. Another important element in these decisions is the distinction from the decision of the House of Lords in Pinochet, differentiating immunity from jurisdiction in criminal proceedings against individuals and in civil proceedings against states. Later, the decision in Jones versus United Kingdom in 2014 consolidated this understanding of the European Court of Human Rights.